Fantastic. Thank you, everybody, for joining us. Welcome to our third Wednesday workshop. Tonight, I have with me Silna Stain of SSL Incorporated and Bruno Samao from Bruno Samao Attorneys. Welcome, guys.
Hey, guys.
Hi. It's nice to be here. Just a little later than normal, but it's nice to be here.
Yes. So obviously, with everyone now going back to work a bit more, the workshop won't be held at 1 o'clock. It'll be held now at 6 o'clock every Wednesday. So just bear in mind that for the next one as well. Welcome, guys. Hope you guys are all doing well. Let's get started. One of the questions we have this week would be regarding the signature of documents. People obviously are stuck at home. I know for me, myself, I don't have a printer or a scanner at home. If I need to sign a document, whether it be a rental deferment agreement or any kind of agreement during this time, what is the procedure for signing such a document and getting it back to the other party? Silna, maybe you wanted to answer this one?
Yes, so this is a question we're getting quite often, because at this stage, I don't think there's a lot of people signing new lease agreements. I think at this stage, lease agreement signature is luckily not the biggest problem we are faced with right now, but we have rent deferment agreements, as you rightly said, or deposit utilization agreements, or extensions of lease agreements, things like that. So the practical implication there, where you can't sign a document, is that a lease agreement doesn't have to be in writing. So that makes it quite easy. So when we have to sign a lease agreement, an amendment to the agreement, we will have to the agreement to the letter. So the agreement will typically say, the lease agreement will typically say how it should be done. If it has to be in writing, my suggestion is make sure that the parties record in writing how they are going to attend to this. For instance, say you and I, Rowan, want to amend an agreement. I will send you an email and say, this is the rent deferment agreement. This is the content that we've agreed to. I can't print and sign now, but please confirm that you are happy with that. And so we can prove after all of this that the parties were both aware of the terms of the agreement. And I think that's the thing that's most important. Don't just say, I guess I'm happy with the agreement. Specifically say, I've read the agreement, all the terms, and I agree to all the terms of the agreement. Because otherwise, afterwards, how on earth are we going to prove what the parties agreed to? And then with agreements, for instance, an offer to purchase, where the Alienation of Land Act applies, where we specifically have to have these things in writing, it makes it a lot more tricky, because you won't be able to simply do this verbally or by email. Even if the parties can prove that they've agreed to the terms of the agreements, there's legislation specifically requiring signature. So we've discussed this before we started talking, and we recommend that in any one of these agreements, you simply insert a clause to allow signature by counterpart. What that means is you can sign the agreement on your side, I can sign the agreement on my side, and it will be seen as one contract. So people aren't signing the same piece of paper. That is the non-lawyer version of signature and counterpart. So there are multiple pieces of paper that's being signed, and we can bring this together at the point of transfer. Practically speaking, Bruno, I think you will agree with me here that because we are level 4 providers as attorneys, it does allow us to potentially send a messenger to the purchaser, to the seller, to have the documents signed, obviously following the necessary protocol with the necessary PPE, to have the documents signed. You agree with me, right?
No, absolutely. Absolutely right. So everything that you said, 100%. The only thing I want to touch on is electronic signatures. So what Silna indicated is lease agreements, or many agreements, in fact, don't need to be in writing. It's normally legislation that dictates what needs to be done and the formalities that need to be followed. So that's exactly why she pointed out when it comes to deeds of sale, unfortunately, the interpretation of the Alienation of Land Act doesn't allow us to have any form of signature except in writing, pen and paper. But electronic signatures are allowed in many other scenarios. And you do have different extents of electronic signature. So a very simple one and like an authorized one, which is a far more advanced one that has verifications. So with leases and things like that, one method of doing it is exactly what Silna said. Explain or elaborate how you've read the agreement and how this needs to be considered a signature. There is case law that even confirms that email signatures are considered to be signatures, which is perfectly fine. So if you send it out with your signature in an email and somebody accepts, the often acceptance takes place. There's an actual contract in place by way of email. It is reduced to writing, so it's acceptable and technically signed. Most lease agreements, or most amendments, when we speak about non-variation clauses, if the contract says that this cannot be amended unless it's reduced to writing, then it's actually quite easy because all you need to do is reduce it to writing like an email. If it says signed by the parties, that's where you need to go the extra step and make sure that there's some form of signature with your name on it, or electronic signature in the document. You can do that in Adobe and then send the document off, or do it in Counterpart where you sign here, scan it, email it across, and somebody signs it on the other side. With respect to transfer documents, so if we move away from the contracts and we look now at transfer documents, so I'll allow Silna now to touch on the deeds office and where we stand with that. But the reality is, as level 4 providers, our offices are now open, and technically we can start lodging at the deeds office and effecting transfers. But in order to do that, now we need, again, assistance or cooperation from our clients, the sellers and purchasers, who need to sign. And the question arose, how are they going to sign if we need the originals? And what Silna pointed out is, as a level 4 provider, we can issue permits to our drivers, to our messengers, and our opinion is that we can actually go collect from our clients. So at least that hurdle is dealt with.
I'm so glad you've touched on the electronic signatures in lease agreements, Bruno, because I'm thinking of the TPN leaseback, and I assume a lot of people that's watching this particular webinar are users of the TPN leaseback. And because of the case you've referred to, what's it called again? I can't remember the case's name. There's some forest. There's a forest involved in the name. But that particular case that allowed, where the court held that an email signature could be deemed to be a signature. The definition of signature, specifically in the TPN leaseback, and I suspect in a lot of lease agreements, will specifically say what signature is. So for safety, based on that case, I've excluded an email signature. I only allow advanced electronic signatures. So I think I'm very happy you touched on that, because for you as the user and the landlord or the tenant, don't just look at the body of your lease agreement. Always remember, one of the most important parts of any contract is the definitions clause and the interpretation clause. And I think those are the clauses people are skipping over. And you could very well sit with an agreement that excludes something like it must be an advanced electronic signature, something like that. So just go back to your lease agreement to make sure that you are following the right process. And at the same time, as Bruno rightly said, because of that case, going forward, be aware of the content of your lease agreement, because you could very well accidentally vary the terms of your agreement without knowing it. And I think that was pretty much the basis of that case. So what I always tell rental agents in trainings as well is, remember, if your tenant sends you an email and says, you know what, I actually don't like paying my full rent anymore, I would actually prefer to pay only half, and you quickly reply on your phone, cool, chat later, you actually mean, cool, I will read the mail later, it could be deemed accepted. So I actually think we accidentally opened a very important conversation.
Yeah, no, really.
And I think it's important to just read, especially your definitions.
Yeah, absolutely. And I think that just emphasizes what people miss out nowadays. And we had this conversation last week. We keep speaking about concepts like force majeure and how it applies. But the reality is it's not a blanket statement that we can just go around using in order to try to get out of contracts. The contracts are drafted anticipating certain issues. And we need to be very careful when we read the contracts. What do the contracts state? When it comes to residential contracts, lease agreements, we even need to take it one step further and make sure that Rental Housing Act allows for what the contract states and that the law supports it. So there's a whole range of referring back to agreements. And like Silna pointed out, if the agreement specifically excludes email signatures, then it won't apply. So email signatures are allowed, but if it excludes it, obviously it's not allowed. A recent case law again regarding like WhatsApp contracts, that's also allowed. So everything that you do, the only thing with, and I think people get confused because oral agreements, is it enforceable? It's enforceable, it's just difficult to prove. So if you walk into a lawyer's office and tell us, I entered into this contract, I said this, he accepted. We don't look at it and say you don't have a case because you don't have a contract. You've got a contract. But now if I can actually prove that you have a contract, that's a completely different story. But if you show up with a WhatsApp message, that's slightly different because it's in writing. It's a lot easier to prove.
Yes. I'm glad you say that. I get it so often, inquiries from potential clients, and the conversation always starts with, Silna, can you please do an eviction for me? And I say, yes, okay, what's the story? And the first thing they say is, there is no lease agreement. And I'm like, okay, why is the person there? It's not like somebody's just randomly going to appear in your unit. And then I eventually hear, oh, there was a verbal agreement. I'm guessing you're dealing with a lot of similar things. And it's important to say there is a contract, but it's very difficult to prove the terms of the agreement. And the effect of that is, instead of just having paper before court where we can approach the court on application, we have to lead oral evidence, which means we're going to have to go to trial, which takes us from a 3 to 6 months potential situation to a 1-2 year drama.
Yeah. And I mean, I was actually chatting to Greg about this a couple of weeks ago. Interesting inner city eviction that I have. And on this one, there's a contract, but it was completely unsigned. And the person who signed the contract in 1998 passed away 20 years ago, oddly 20 years ago. And now the kid is staying on the property, but they're paying rent. Rent is being charged. There's statements, but there's no lease agreements. There's a contract like an odd 20, 24, 22 years. I think it was signed in 1994, if I'm not mistaken. So 26 years old. And it doesn't even know about the existence of email. It's the hardest contract to actually work through. But the reality is, to try to prove that is such a mission because everything's tacit. And I get a lot of people that walk in and say, well, we need to evict, but there's no agreement when there's an actual contract, it's just unsigned. And it's the same thing. I'm sure you've experienced this, where you're supposed to actually be able to rely on that signed contract. You just need to inform the court that it's just unsigned, but the people moved in on terms that they were very much aware of.
Exactly, and there's a tacit agreement based on the terms of the written agreement.
Absolutely.
We see weird things, Rowan, honestly.
I'm sure. We were talking about OTPs earlier. What is happening with the functioning of the deeds offices throughout South Africa? Are they back? Are they not back? What is happening there?
I heard Bruno already threw that one to me. He wants me to be the bearer of bad news here. Okay, so everybody lost it of excitement where we saw the deeds office will be open in level 4. So everybody was extremely excited. Yay, deeds office. And it's true. The regulations does allow for the deeds office to be open. Only problem is the deeds office isn't open and the deeds office isn't functioning yet. Not because they're not complying with the regulations per se. They don't have sufficient PPE to keep everybody safe in the deeds offices. So we know for a fact Cape Town is closed. We know for a fact Nelspruit is still closed. Pretoria is closed. Bruno, you said you were just waiting for confirmation on
Yes, yes,
Joburg,
yeah.
but we
Yeah.
are suspecting that Joburg is closed as well. So at this stage, unfortunately, as much as the regulations allow for the deeds officers to open and to function, unfortunately, because they don't have the necessary PPE and enough things to keep everybody safe, they are all still closed. So.
No, absolutely. I just have to point out many times a lot. Obviously, like in conversation, a lot of people jump to the criticism of some of the government departments. It is bad that the deeds office isn't open, but I do have to applaud them for at least taking precautions, because I spoke to a prosecutor today that I'm friends with, and on their side is the complete opposite. The courts are open and it's functioning, this particular court, but it's a disaster. There's no distancing. There's absolutely no PPEs, nothing. And these prosecutors are worried because now they need to step into court. It still has a lot of people. Everything's just going as per normal, and it's quite dangerous. So yeah, it's kind of ironic, but yeah. So some courts are actually doing a dreadful job in protecting their staff. So I applaud the deeds office. At least they're trying.
Yeah.
If it goes on for too long, then that's going to change. But yeah.
but for the moment, we understand.
Yeah.
Then another thing, there is a case that is being thrown around social media quite a bit with the heading that tenants don't have to pay rent due to force majeure. The case's name is Coy versus Middle Ground. What does this case say? What is happening? It doesn't sound correct, but it's being thrown around quite a bit. What is the actual standing?
All right, so
Bruno, yeah. Whoever wants to take it, go ahead.
Still go for it.
So this particular case, it's been the heading is misleading, Rowan, because it says tenants doesn't have to pay rent because of force majeure. So if you read the whole case, the matter was, the judgment was handed down in the Supreme Court of Appeal on the 23rd of April. So already when I saw that, I thought, if you get yourself into the Supreme Court of Appeal somewhere between the 26th of March and the 23rd of April, somewhere you did something pretty impressive. For everybody out there to get through from a start of a case to the appeal court is going to take you about 18 months to 2 years if you are doing a good job on speed. I'm just going to leave it. But so if you're really quick, you won't be able to do that. So read the full case. Actually, it was Elise Leroux from Expello sent it to me just as a heads up, a warning. Everybody's going to ask you this question, so heads up, here's the case. And the truth is, the content of the case actually doesn't have too much to do with a lease agreement. There was a lease agreement in place where the tenant, which is not really a tenant, I'll get to that, was actually using the land to extract peat from the land. Yay, for the whiskey drinkers, you guys know what I'm talking about. So to extract the peat from the land. Then there was an environmental issue, and government said, so the correct department here, said that they are not allowed to extract the peat anymore, so they couldn't use the land for what they were renting it for. So then the court specifically held that the agreement between these two parties is sui generis. Sui generis means a unique thing. There isn't a lot of these things. So it's sui generis with a lot of elements of a lease agreement. And Bruno, I would like you to take the basically permanent impossibility, that part. And I think that's the most important part in this case, where the court said, but this isn't a lease agreement, and it's actually sort of a sale agreement. And the peat is the thing that's being sold. Now government made it impossible to extract the peat, which makes performance impossible, which means if I'm buying something from you and you no longer have it, I don't have to pay for it, because it would be silly to pay for something I can't have. And there isn't this element of permanent impossibility, which I think is important. This case has nothing to do with COVID-19, and it doesn't even have too much to do with rentals. And COVID-19 specifically isn't a permanent state of impossibility. So on that point, I'll throw it back to you, Bruno, on permanent impossibility, and what is the effect then of this case on the COVID-19 current situation?
Sure. Yeah, so it's actually quite interesting, but as you pointed out, so this has nothing to do with COVID. This is probably running through our courts for a couple of years now. So the timing is really all that brought, the only reason this case was brought into the spotlight. And you do have different levels of impossibility. So you're looking at impossibility that's permanent in nature, which basically effectively voids the contract, if you want to put it like that, meaning that performance is impossible. And in our law, we do deal with supervening impossibility. So all that supervening means is at a certain point, the contract was possible. So there was a valid contract in place and something happened after the fact. If it's not supervening and the contract was impossible from the beginning, then it's void from the beginning. So supervening is when something happens during the duration of the contract. So for example, something is legal and all of a sudden it becomes illegal or unlawful, and that's where the supervening comes in. So in this particular instance, if something is considered to be entirely unlawful and cannot be done anymore, it simply cannot be performed. Whereas if we start looking at, for example, elements of temporary impossibility, it means that something's only temporarily impossible, so you can't void the contract in its entirety because of that, because it's only temporary. But if we need to go into case law, and maybe that's a nice discussion for next week, because I do remember there being specific case law that defines how relative temporary is. Because if the intention of the contract is to, for example, if there's a specific shipment, let's say there's an event overseas and a specific shipment needs to be sent out in 2 weeks' time, the reality is if it goes beyond the 2 weeks, it is more permanent, because after that, it's completely irrelevant. You can't send shipments out. So it is relative to the purpose of the agreement. But for example, I can't imagine rentals being permanently impossible just because of 1 or 2 months, a person not being able to make use of the property. But if it goes on for a really long time, then we start looking at the fact that, you know what, these contracts may be voidable if force majeure actually applies to them. But that's actually a nice conversation to expand on next week. Yeah, let me actually just go back and find that case law and read through it again.
This is how boring lawyers are. We read case law and then we talk about it and we bring other cases into cases. Like, I kid you not, this is how we do it. It's
just a vicious cycle.
It is, but I think it's important. This case came, as Bruno rightly said, at the perfect time where everybody suddenly, it's like, remember, when we had the Oscar Pistorius trial, nobody ever knew that there is something like dualis eventualis, except for us loser lawyers, né?
Yeah.
So, and then suddenly you read the words dualis eventualis in the huisgenoot, julle. And now suddenly this is happening with this mile, force majeure, supervening impossibility. I just need everybody to know it's not such a big surprise for us to see these words. We know this. We've been trained on this like way back when already. So it's nothing new. It's just coming into the news now because a lot of people are relying on this. And I think it's important to know that we all know at this stage for a tenant to just use this force majeure as a blanket approach to, I'm not going to pay rent because I can't get into my premises. That is not where we stand. That is not the intention of force majeure. And as you rightly said, temporary impossibility wouldn't make a contract voidable. And I think it's a very important point that you've made.
At best, remission, but like we mentioned before, in residential properties where a person's staying on the property, that's not going to fly.
Great, fantastic. Then another thing is, during this time, what is the process of blacklisting a person, a tenant who's not paying their rent? How can you go around doing that? Are you allowed to do that during this time? What exactly is the process for that? Bruno, maybe you could take this one.
All right. So in order to blacklist someone, so TPN, Michelle from TPN spoke about this right at the beginning of the lockdown. So for a person to be blacklisted for the lack of payment of rent, a certain notice needs to go out first. Only after that notice is sent out and there's a lack of reaction, can the actual listing be uploaded through the credit bureaus. So what happened almost right at the beginning of the lockdown was, in terms of the National Credit Act, which is the act that, in terms of which these listings are normally made, there was a suspension or so basically the idea is the time period for those breaches is no longer running. So you cannot send notices now and expect the time periods to count. There's basically been a suspension of this. Effectively what that means is during this period of time, there will be no blacklistings because you can't give notice that you intend to blacklist. And therefore, until that's uplifted, blacklisting won't be allowed. But what I think, Rowan, you're going to share that.
Yeah.
If you don't mind just sharing that infographic.
Am I sharing it or you?
Oh, no, you're sharing it. That's, we've got it right here.
That's the right one.
Yeah, so if I recall correctly, the important part is that paragraph at the bottom.
Would be this one here.
Yeah. A tenant can be blacklisted with a credit bureau for failing to pay rent. However, the landlord is obliged to follow the breach process, either in terms of the Consumer Protection Act, the Rental Housing Act, or the lease agreement before reporting the default to the credit bureau. The breach notice may only be issued after the lockdown has ended. So this is something that Silna and I wanted to comment on. With respect to, exactly.
I'm sorry, I just realized everybody can still see my face. I'm sorry.
Someone's very excited over there.
So this level of providing information with the lack of detail. So I get what they're trying to say. And it's a nice notice for people to kind of understand more or less what their rights are. But this is completely wrong because it sets the wrong impression. Breach notices in terms of the Consumer Protection Act and the lease agreement are allowed. We're still issuing notices demanding payments of rent. That hasn't been stayed anywhere. It's simply not. The stay has only been on the blacklisting notice. And there's an official notice that came out stating that. You will not find the equivalent with the National Credit Act. So to say that there is a stay doesn't make sense because there simply isn't. It's similar with contracts. There's nothing at all that says suddenly notice periods and contracts are now suspended. The regulations don't say that. The president hasn't said that. So unfortunately, this is creating the wrong impression and giving people this idea that they can't be placed on terms, which the effect on us, Solna, is that how do we go to court if now everyone believes that we're not allowed to issue letters of demand?
And that's exactly the problem. I think why I roll my eyes so hard. A lot of the content of this document, Rowan, if you can maybe just zoom out a little so everybody can see the full what he looks like, because he's been going around. Because there's Gauteng written at the bottom, suddenly we all feel this must be correct. And like you rightly said, Bruno, I think it's just the way it's been done that's unfortunately not on point. Also, this is based on the full lockdown regulations. This is not level 4, and I think this is crucial to know. Remember, Regulation 19, in terms of the level 4 regulations, does 100% allow us to even initiate new eviction proceedings, to even obtain our orders. Just the execution of the eviction orders are stayed. So this document, as much as there's a nice coronavirus picture, and at the bottom a Gauteng provincial government emblem, yes, but this was based on definitely full lockdown content. And unfortunately, some of the things there, for instance, like you said, the breach notice, that's only in terms of the NCA. In terms of the Consumer Protection Act, 100%. We can place tenants on terms. We can cancel the lease agreements, and now we can even commence eviction, even obtain the eviction orders, even execute in very specific circumstances where the court allows us to do that. So this document we're aware of, and I think it was very important to address it. Thanks for bringing it to our attention, Bruno, because I think this is the type of thing that very often causes extreme confusion. And for a tenant that sees this, that believes that nothing bad can happen to him if he doesn't pay rent, I think, unfortunately, we're going to see quite a big number of the tenants ending up with judgments against their names because they honestly believe that we can't proceed with legal proceedings against them. And unfortunately, that's incorrect.
And I suppose the worst part of this notice is it's not dated. Which is also frustrating because when I received it when level 4 was already in play. And if you read it, it speaks of us not being allowed to approach courts, to initiate any proceedings in court. So that's blatantly wrong. So it could have caught people by surprise thinking, oh, you know what, something new came out. But the reality is we've got practice directives from the courts and the Justice Department saying, yes, you can approach court. And then we've got a notice from the Gauteng government saying that you can't. That doesn't make sense. And I'm sorry, but a notice with little pictures is not tantamount to rules and regulations and law. It's simple as that. This is not a gazetted regulation. So people cannot come and start holding this up every time there's an issue and relying on it. It's bad. It is bad. This should probably be retracted or corrected or dealt with at least.
I like what you said. If there's pictures, it's probably not gazetted, because let's be fair, the actual regulations that we've read, as it is, you have to sit on the side and draw a picture for yourself to try and understand it. But unfortunately, it doesn't come with pictures.
Lawyers are boring. We don't use pictures. This is not by a lawyer. It's
except, Bruno, in fairness, if it was me, then we would have known.
Okay, fantastic. Thank you so much. I mean, it really helps that you guys have clarified that particular notice, because there have been quite a few going around that are fake news. So thank you for you guys, also the Property Law Alliance, for clarifying exactly which notice and regulations are the correct ones and which ones are not the correct ones. Then lastly, I know obviously level 4, the number one question on everyone's mind, which we did talk about last week, but I think everyone is still asking that question: can people move? Whether it's moving out of their house, what is it? I can already see Silna's shaking her head, but what is the stance now as of the 6th of May, 2020?
Yeah, so nobody can move. Nobody is allowed to move. You're allowed to return. And I think, Bruno, you and I have discussed this at length. What does return mean? I don't think I've ever had a conversation that long with anybody about one word, except for the word. The only other time I've had a conversation that long is the word between, in terms of Section 14 of the Consumer Protection Act. So between and return. This is the type of things that keeps us awake. So return, we've dealt with that a lot last week. So obviously the webinar is available that we've had last week. So unless you're returning to where you were for work purposes, or you're now tired of the family, you thought you're just going to hang out with them for 3 weeks, turns out now it's 5, and you know, you would like to have your own solo isolation, again, you're allowed to return to where you are. If you move, the regulation says you can use a bakkie and 2 people. A bakkie and 2 people isn't the way you move an entire house. Even me, I'm pretty minimalistic, but even I can't move on a bakkie and 2 people. That's not going to happen. So that's not a house move. That is potentially you, and you might have to take like a new bed, because this, I'm using an example the minister used, specifically, you're tired of your bed, you need a new bed now. I kid you not, this happened. And you can put a bed on a bakkie with 2 people, you can move that. But that's not a full move. So you can't move. And I think a very important thing is, I've had a lot of questions, and I suppose you too, Bruno, from people saying, especially rental agents, saying, but my landlords are opening their places for tenants to move in. What I'm saying is, you as the landlord or you as the agent will never have an obligation to enforce the regulation. But stay away from this quickly. I'm just going to take a chance and see what happens, guys. Landlords that's disconnecting utility supply now, that's doing a lockout, people that are allowing moves, agents that are doing inspections. It's not like before COVID, where you can potentially be slammed with a spoliation order. You need to place the person back in possession, and your worst case scenario is a hefty cost order. What we are facing now is a criminal offense in terms of the National Disaster Management Act. This is a real crime. And you're going to not just run the risk of going to jail for 6 months, you will, even if you pay a fine, you have an actual criminal record against your name. Not like that one time that you were caught drinking and driving and you had a bit of a slap on the wrist. It's an actual criminal offense. In terms of the National Disaster Management Act, your visas that you want to get because you can't wait to get traveling after all of this, you run the risk of not getting that, of losing the use of your passport, of losing visas. The consequences are much more severe now to breach the regulations. So the whole thing of, let's see if we get away with it, it's a true South African way of doing things. But if you do not get away with it, I think the consequences are extremely severe. Or am I being a drama queen now?
No, I absolutely agree with you. And I suppose that's the problem, is there's so much uncertainty that it's very difficult to advise clients, especially out in the open, at the risk of certain advice being taken and lines being crossed. Because, I mean, we discussed earlier today, take, for example, the fact that certain people would be allowed to return to work, right? So part of that return is also return to work, which means that you might find people that need accommodation for that work. So it's not to say that those people cannot suddenly move into a new place if they have to move into a new place. It can happen, and the regulations allow for that. So on the one hand, there are situations or circumstances out there that allow for it. But now as a landlord, is there an obligation on you to ask these questions, or can you just close your eyes? And if somebody approaches you and says, I want to move in, do you close your eyes and just say, well, move in, I'm going to assume that you're allowed to move, so I'm not going to ask anymore? And the reality is, my gut, and like I said, it's only my gut, tells me, listen, there might not be all that much obligation on a landlord to ask the questions. But the problem is that, do you want to take that risk? Because we don't know now, would it be considered to almost be an accomplice to a crime being committed, or not? And I suppose that's taking that chance is a very big risk on an individual. So I would rather say, be cautious, be conservative. If people aren't allowed to move, they aren't allowed to move. If somebody does approach you, make them confirm that they're allowed to do it. And if they put themselves on the line and you actually indemnify yourself and they confirm and they warrant that everything they're doing is lawful, then possibly in those circumstances, a landlord can wipe his hands clean, and it sits in, in the lap of the tenant that's moving around. But that's the best I can offer or suggest. I don't know if you agree, Silma.
I agree 100%. When we spoke earlier today, you used a beautiful example of the landlord not having the obligation to really go Sherlock Holmes on the tenant to make sure he's complying with rights. The example you used was, if somebody moves in to your premises, you the landlord, tenant moves in with a minor child, single parent, minor child, you don't have an obligation as the landlord to check that that parent has the parental rights to move with the child. If the other parent then suddenly pops in and says, "Whoa, what? You don't have the right to move with my kid," the landlord isn't responsible for this. And you also use the example of illegal immigrants, and I agree with you 100%. The landlord doesn't have the obligation to go Sherlock Holmes and look at the permits and then call 500 people to find out if this is legal. I do believe, however, common sense must prevail. If somebody doesn't have a permit and they want to move from this house to 5 blocks away from here, chances are that's not returning. And if you are the landlord, the agent, whoever else, you are exposing yourself to a risk. And most of all, the tenant that is doing the moving. I saw people getting arrested, for fetching their toddler from the beach. What I'm saying is, you don't know which police officer you're going to run into. Maybe it's somebody that's relatively chilled. You can talk yourself out of it. But if you run into Chuck Norris of the SAPS, you might very well be on the wrong side of the law. And unfortunately, we only do evictions. We don't even do criminal law, so we're not going to be able to help you.
And I suppose the thing is, context is everything. And when discussing the regulations and answering questions, they were very clear. They only ever used examples of, yeah, sure, move that bed to your flat in Hillbrow, which was his exact words. And so the reality is, they've always mentioned it in that context. So we understand from that what the purpose of this regulation is. So if it's apparent that this guy is contravening the regulation, as a landlord, be very careful, because now you're aware of it. It would really only be in circumstances where you're completely oblivious. Nothing gives you an indication of a contravention, and this guy assures you that he's allowed to do it. Maybe in those circumstances, but yeah, it's playing stupid isn't really the answer. It has to be quite apparent and blatant.
Fantastic. Well, that's all the time we have for this workshop tonight. Thank you so much, Bruno and Silna. It was a fantastic evening. Very, very insightful. Thank you very much.
Awesome. Thanks, Rowan.
And then to all of our, sorry, Silna?
No, I'm saying it was brilliant. Thank you.
To all of our PLA members, if you have any topics or issues to discuss at our next Wednesday workshop, please comment, let us know, give us a message, and we're more than happy to discuss all the issues and topics next week. Fantastic. Thanks, everybody.
Awesome.
See you next week.
Cheers, guys.
Thank you.
Cheers,
Bye-bye.
Bye.
Bye.
I think it's still recording, just not on Facebook.
Yeah.